Good morning. This is Andrea McEwan. Thank you for logging in. This is a presentation on tips and pitfalls for acting as an attorney for property and personal care. The audience today is broad. There are lawyers, accountants, family members dealing with their aging parents, among other people. So it is difficult to assess the level of knowledge that people have about these issues. Some of you will have in-depth knowledge, and some will have less. And because of this, I'm going to start the presentation with some basics, and we'll address more complicated issues as we proceed. Some of you have also already sent in some questions. I will try to address these in the appropriate place, and please feel free to send in questions as we go as well, and I will do my best to address them. There will be a short time for questions at the end as well. I should say that nothing I'm saying should be interpreted as legal advice. I'm giving an overview of the area and some tips and tricks. If you have a specific issue, I would recommend that you retain a lawyer to give you advice, as most situations will be fact-specific. The advice would not be the same in all circumstances. There's a lot of gray in this area of law, and so it may be important for you to talk through your specific problem with somebody who practices in this area. So I just want to give a quick overview of what a power of attorney for property and personal care is. They are legal documents that give another person the authority to manage your affairs if you can no longer do so. I've said there are two types of powers of attorney: a continuing power of attorney for property and a power of attorney for personal care. This isn't entirely true. There's also a general power of attorney for property. The distinction between the general power of attorney for property and the continuing is that a general power of attorney for property does not continue once a person becomes incapable. So a continuing power of attorney for property continues during a period of incapacity, and that's in fact the purpose of the document. The first type, the general, is generally used when people travel, for example. So when I went backpacking after university, I signed a general power of attorney for property so my parents could look after my bank accounts. If I'd fallen into a coma, that would no longer have been active. So a continuing power of attorney for property can be used during temporary incapacity, such as a coma, or during permanent incapacity, such as advanced dementia. I'm only going to be talking about continuing powers of attorney for property today and powers of attorney for personal care. So just to note, these documents are only active during the grantor's lifetime. They terminate on the grantor's death. So that means once a person dies, you can no longer use them. This is surprisingly, a lot of people don't understand that. So a continuing power of attorney for property. So this allows your attorney to deal with your financial matters. It's an extremely powerful document. Your attorney for property can do anything with your property that you could do if you were capable, except make a will. So a person can deal with your bank, pay your bills, or sell your house. This document is actually active from the date it is signed. If you don't want that to happen, if you want it to only be active when you become incapable, you can have a springing form, which basically says, this is only active after I've become incapable. And there will have to be a mechanism in the document itself for determining incapacity, such as a doctor's note or a capacity assessment. The document must be witnessed by two people who are over 18. They cannot be the attorney or the attorney's spouse, the grantor's spouse or partner, a child of the grantor, or a person who is under guardianship. As a practicality, as to who to appoint as your attorney or attorneys for property, if you know your two children don't get along, for example, don't appoint them jointly, because they'll have to make decisions together. So, if they can't decide what to eat on any night without arguing, they probably won't be able to make decisions about how to manage your property. So it's likely not a good idea to appoint them together. If one of your children, often people appoint their children, is not good with money, you probably shouldn't appoint them either. If they've gone into bankruptcy, or they have a gambling problem, or they like to to play with the stock market, it's probably not the person you want managing your property when you can't do that yourself. People often don't want to be seen as favoring one child over another, but some people have skills which make it more appropriate for them to act as an attorney for property, an accountant, a lawyer, a financial advisor. Somebody like that is probably somebody who might be good at managing your property. So just, some more practical considerations. Your attorney for property must be at least 18. They must be capable of managing their own property. Practically speaking, if you're appointing your spouse who is of a similar age to you, you probably want to have an alternate in case they are also incapable at the time you need somebody else managing your property. While it's not a restriction, you probably want to name somebody who lives near you. This is, it's a difficult job, and it's easier if somebody is close by. And most importantly, you want to make sure someone you trust, you appoint somebody you trust to act in your best interests. And family dynamics, again, are important when naming your attorney for property. If there's difficulty, if you're not sure who to appoint, there are independent trust companies and lawyers who will act as attorneys for property, although they will charge a fee, and we'll get to compensation later. So the power of attorney for personal care. So it allows a person to deal with your personal care if you're no longer able to do so. Personal care includes health care, nutrition, shelter, clothing, hygiene, and safety. And so this means the attorney for personal care can make decisions about the type of medical treatment you receive and where you live. And power of attorney for personal care is only active from the date the person becomes incapable. It can't be used before that time. It doesn't need to be in any specific form, but it must name a substitute decision maker, be witnessed by 2 people, it must be in writing, and it may contain directions or wishes about future personal care. Often people choose to put in information about whether or not they want to be resuscitated, whether, other types of issues related to treatment decisions right in the document. And that can get complicated for the person who's acting, but again, we'll get to that a bit later. So the attorney for personal care must be at least 16, must be capable of managing their own personal care. You can't appoint someone who provides you with health care for compensation, or who provides you with residential, social, training, or support services for compensation. And the point of that is so that there aren't any conflicts of interest, or to reduce the possibility of a conflict of interest. Again, practically speaking, if you're appointing your spouse, which most people do, who is of a similar age to you, you should appoint an alternate in case your spouse is also incapable when you need somebody to make decisions for you. Again, it's better to name somebody who lives near you, although not always as important as it is for property, but again, it is better. And again, most importantly, it has to be somebody you trust to make these decisions for you. And again, family dynamics are important. The same issues arise with appointing children together. Again, if your children can't get along, they're probably not going to be able to make these difficult decisions together. So that's something you should think about. So just a brief overview. So the Substitute Decisions Act is the governing legislation for these documents and for the attorneys. It defines capacity to grant a continuing power of attorney for property and a power of attorney for personal care. And it also defines capacity to manage property and capacity to manage personal care. So just a little bit about capacity. It's situation-specific, time-specific, and decision-specific. So what do I mean by that? So situation-specific, for example, if a person is in a lawyer's office or in a doctor's office, they may be nervous, and that may impact their capacity. Time-specific, again, sometimes people are not very good in the morning, whereas they may be capable in the afternoon if you visited with them then. For example, another example is somebody who is an alcoholic. They may not be capable when they're drinking, but they may be perfectly capable when they're sober. And decision-specific means that each decision, so whether or not to grant an attorney for property, whether or not to grant an attorney for personal care, has a different capacity required. So what is the capacity to manage personal care, for example? So that's set out in Section 45 of the Substitute Decisions Act. A person is not capable of managing their personal care if they're not able to understand information that's relevant to making a decision concerning his or her own health care, nutrition, shelter, hygiene, or safety. And each of those 5 decisions is different. So you can be capable of managing your hygiene, for example, but not capable of managing your safety. And the person, so that's the first leg of the test. And the second is, they're not able to appreciate the reasonably foreseeable consequences of a decision or lack of decision. So an example of this is that a person with a traumatic brain injury, for example, may not feel hot or cold. And so they may not understand what could happen if they go outside in sort of -20 weather without a jacket. So that person may not be capable of managing their safety. Another example is a person with Alzheimer's may not feel hungry and may not understand what happens if they don't eat. So that person may not be capable of managing their nutrition. And then with respect to property, again, this is set out in the Substitute Decisions Act. And Section 6 of the Substitute Decisions Act provides that a person is incapable of managing their property if the person is not able to understand information that is relevant to making a decision in the management of his or her property, or is not able to appreciate the reasonably foreseeable consequences of a decision or lack of a decision. So, a lot of people, as they become incapable, may be more vulnerable to some of the scams that we have now, the CRA scam. There's all sorts of other ones. So a person may not understand that if they give their money to this person at the end of the phone, that they may not have that money anymore, or that if they make risky investment decisions, that it may mean that they lose all of their money. And there's obviously lots of other examples, but those are just some easy ones. So I'm going to stick to the attorney for property for a period of time. So what are the duties of an attorney for property? So first of all, an attorney for duty has a duty to account to the incapable person during their lifetime and potentially the beneficiaries of the estate on the incapable person's death. So what that means is that they have to keep a written record of all transactions that they undertake with the person's property. They have to be able to account for every single penny that is spent. So you need to keep all voucher materials, all receipts, all bank statements, all invoices, anything to do with, if you buy the person food, you should be keeping receipts of that purchase. The person is also obligated to review the grantor's, the incapable person's will. And then, for example, if there's a specific piece of property that's granted to somebody, that piece of property should not be disposed of unless it's necessary to provide care for the incapable person. So if the person needs the money, obviously you're allowed to sell that piece of property, but if they don't, then you can't. The incapable person must be involved in decisions to the extent possible. This means, even if you're not sure if the person understands, you should review bank statements with them, review decisions. I mean, obviously each situation will be different, and you have to consider the person's abilities and if there's some behavioral issues based on their dementia or anything like that, you may want to think about how you're involving them. But you should try to involve them to the extent that you can. And you must consult with the attorney for personal care. So obviously there's a lot of overlap in the two roles. The attorney for personal care will be making decisions about how to provide care. They may need to hire personal support workers and that sort of thing. So the attorney for property needs to consult with them to find out how much money they need and what's appropriate in the circumstances, considering the assets available. This gets to, I think a lot of the questions are around how to protect yourself from liability as an attorney for property. So first of all, and this goes back to the duty to account, but keep meticulous records. Again, make sure you can account for every single penny. Keep a detailed list of all transactions and keep every piece of paper that you can. You can keep them electronically, or you can keep binders or boxes, or however you find it easier to organize it. Just make sure you keep them. Make sure you're involving the incapable person in your decision making. Take detailed dockets of the time you spend acting as an attorney for property. So, maybe have a diary or a notebook and just note down every time you do anything that is involved in your role. This may become important later if somebody challenges your compensation or if somebody challenges what it is that you've done. And make sure you don't see, this seems obvious, but sometimes it's not. Don't do anything that could be seen as favoring yourself. Some examples are don't put bank accounts into joint names or homes into joint title without speaking to a lawyer to make sure these transactions are properly documented with trust agreements or otherwise. And so often people, they start trying to do probate planning for the incapable person, and they start putting bank accounts into joint names because they think it will be easier. And this can lead to a lot of suspicion from other family members and can become a real issue after the person dies. So I would caution you to make sure that you're speaking to somebody before you make these decisions. There can be tax consequences to some of these things that people don't think about. For example, having something put into joint title. Does that mean that the person is going to lose the principal residence exemption? Are there land transfer tax issues? There are all sorts of issues that can come up that people don't think about, so they should. So again, if you're making gifts, you should be careful. So you can make gifts to family and friends if you have reason to believe that the grantor would have made them if they were capable. You can also make gifts to charity if there's evidence that the grantor or the incapable person made similar gifts when they were capable, or if explicitly authorized in the continuing power of attorney document. But you have to be careful about this. So if the person regularly, made gifts of $50 and you start making gifts of $500, that's probably not going to be looked on well when somebody is looking at your accounts, if somebody looks at your accounts. Make sure that you get advice from a financial advisor to make sure that assets are invested wisely and conservatively. If you're getting advice from somebody, then that's good protection from you, from an expert in the area. Get tax advice. People often overlook tax advice, and it's really important to look at the tax effects of taking or not taking steps. And you can pass your accounts if you're very, very worried. So if you're appointed jointly with somebody, again, you need to make sure you're working with the other person. So you can't act on your own. And I just recall a question. I'm just going to have a quick look at the questions about this. I can't find the question at the time, but I'll try and come back to it. So don't act on your own. You have an obligation to work with the other attorney and to make decisions together depending on how the document is worded. And so if you're concerned about how the document is worded, obviously you should talk to a lawyer about that. But what can go wrong? A lot of things can go wrong. So there are many, many variations of what can go wrong. First of all, is you can do everything right as an attorney for property, and your siblings or other beneficiaries can still complain. And again, this is why you need to take meticulous records and dockets of how you spend your time. So if you don't involve the other attorney in your decision making, you could be removed as the attorney for property. So the other attorney may bring an application to have you removed for acting without them, and you will be forced to explain why you shouldn't be removed or agree to be removed, and any litigation is costly. So this can be extremely costly, and the courts are unlikely to order that your legal costs will be paid out of the incapable person's assets. The judges have been quite clear that if attorneys are fighting, it's their issue. Now, there's a slightly different twist. If somebody is abusing a power of attorney document and is taking advantage of the incapable person, then that's slightly different, and you may get some of your legal costs out of the incapable person's assets in those situations. But if you aren't doing your job properly, you're going to be paying your legal costs on your own. The other issue that we see a lot is that somebody else, a sibling or a caregiver or somebody who is a predator of some variety, may take your parent to a lawyer or may otherwise create a new continuing power of attorney for property document appointing them as the attorney, and that document will supersede yours. So the document that was signed most recently in time is the one that is to be used. And in these situations, often the person didn't have the capacity to appoint a new attorney. And we talked a little bit about what that capacity is earlier. There is a question actually as to who gets to decide about whether or not the person had capacity. And generally the lawyer is the one with the lawyer who is creating the document is the one who has the obligation to determine whether or not they think that person has the capacity to execute that document and to grant a power of attorney. Some lawyers are better at this than others. And sometimes a person may present very well for a short period of time, and it may appear that they had capacity when they didn't, or maybe they're being influenced by the person. So it's really the lawyer's obligation. But if you don't think that your parent had the capacity to grant this new document, then you can take steps to challenge it. But again, this is a legal application, and it's expensive. And the courts will look at medical records. You may need to get a capacity assessment for the person to try to decide whether or not they are in fact capable of granting this document. And it can be a complicated and expensive process. The problem is that if you don't take those steps, then the person may take advantage of the incapable person. I have, this is happening more and more often, and these types of disputes take up a lot of my practice these days. So I have files where the attorney for property has sold the person's home and pocketed the proceeds, where they've drained bank accounts. I had one case where a man who had appointed his daughter as his attorney for personal care and was still living in his home, and his daughter sold the property out from under him, and he was forced to move. Other things that can happen is that the house can be put into joint title, and then after the person dies, that person will try to take the house. And these things are difficult to unwind after the fact, although it's not impossible. So what are some red flags that somebody may be contemplating these types of predatory actions? The person starts to isolate the older person. The older person starts saying they can't afford things they should be able to, such as food. The older person doesn't have basic goods. So, they don't have soap, they don't have food in their fridge, and all of those types of things. Or the attorney appears to be living off the older person. The person may move into the person's house and start to live there for free. So there are all sorts of red flags, and if you start to notice these things, I would caution you to speak to a lawyer about them, to talk about the steps that can be taken to try to prevent this type of abuse. So compensation as an attorney for property. So a lot of the questions that were sent in advance relate to compensation. So I will try to go through some of those questions here. So attorneys for property are entitled to compensation. It's explicitly set out in the Substitute Decisions Act in Section 40. And so I've got the prescribed rate on the slide. So it's 3% on capital and income receipts, 3% on capital and income disbursements, and 3/5% on the annual average value of the assets as a care and management fee, and that's if you're taking care of the person's assets for a lengthy period of time. So you can take compensation monthly, quarterly, or annually. But it's important to remember that a different standard of care applies if an attorney takes compensation. So an attorney who does not receive compensation for managing the property has to exercise the degree of care, diligence, and skill that a person of ordinary prudence would exercise in the conduct of his or her own affairs. But a guardian or an attorney who receives compensation for managing property shall exercise the degree of care, diligence, and skill that a person in the business of managing the property of others is required to exercise. And so that's actually a fairly big distinction. And so when you're thinking about whether or not to take compensation, you may want to think about that. So if you're worried about certain beneficiaries becoming litigious and challenging your compensation, at some stage, likely after the person passes away, the incapable person passes away, you might want to start an application to pass your accounts. And this means that a court signs off on what you've done. There's a court order saying everything you've done is okay. And this judgment is the best protection you can get from any future liability or litigation. The downside is that it's an expensive process. You need to put your accounts in what's known as court format. This is set out in the Rules of Civil Procedure. And if people make objections to certain transactions or to your compensation, you have to respond, and it can be a lengthy process that ultimately could culminate in a trial. Now, in Toronto, we have, it's actually in Toronto, Ottawa, and the County of Essex, we have mandatory mediation, which gives everybody an opportunity to resolve these objections. But again, this is still a lengthy and can be an expensive process. So if you're really worried, you can resign as an attorney for property or personal care. And the Substitute Decisions Act sets out the steps that you have to take to do that. If you've been acting for a period of time, you'll likely want to pass your accounts, or at least try to get sign-off on your accounts from the other beneficiaries, showing how you've managed the property. From the date you started doing it to the date of your resignation. The issue with that is that if there's nobody else who's appointing, if there's no alternate or nobody who's willing to act as the attorney for property, then the person may not have anybody to act, and there may need to be a guardian appointed. And again, a guardianship is a court process to appoint a guardian who acts basically as the attorney for property. And the obligations are the same, and they're also set out in the Substitute Decisions Act. So I just want to take a little look at some of the questions here. So in terms of whether or not you should take compensation, that's really only a question that you can answer. Again, you want to think about the different standard of care. And if you do take it, if you're worried about, if there's no concern, if your siblings know that you're taking it and then they have no issue with it because they understand the work you've put in, then it's likely not going to be a problem. But if there is a concern, you can take it and maybe set it aside in a different bank account and not spend it until after the person dies. And if there's a question about what you've done, at least, and you have to repay some of it, then there's no issue with where the money is, and you can simply repay it. That's often advice that we give. So what is a passing of accounts? We can just talk about that a little bit. So on a passing of accounts, a court can review your compensation. So I talked about what the prescribed rate in the Substitute Decisions Act for compensation is, but this can be adjusted by the court in appropriate circumstances. And the factors that the court will look at are the magnitude of the trust or the magnitude of the assets that you've been managing, the care and responsibility springing from the size of the property, the time you spent, and this is why I say it's important to keep dockets of the time you spent so you can show exactly how much time you spent doing this, the skill and ability displayed. So if there were complicated transactions, if there were a variety of properties that needed to be sold, all of that will play into the amount of compensation that you have to take, and the results that you achieved. So if you invested the property and you got a good rate of return, or if you sold the property for a lot of money. There are all sorts of things that will play into the amount of compensation that you have to take. And again, I've said it before, but in some cases, passing your accounts is the best protection from litigious family members. So I have another question here about corporate versus individual powers of attorney and fees. So again, if a person has appointed a trust company as their attorney for property, often the trust company will give them a copy of their fees in advance, and that can be appended to the power of attorney document, or it can set out in the document itself that the attorney agrees to pay the reasonable fees of the trust company on whatever rate it is that the trust company has agreed. And again, the individual compensation is set out in the Act. Now, the document itself may say you can't take compensation. If it says that, you can't take compensation. Or it may say you can, and that you agree that it should be in the amount set out in the Act, or some variation. So you should always look at the power of attorney document first before you decide whether or not to take compensation. And I'm just looking at some new questions that came in here. So one question here is, can a continuing power of attorney be revoked, rescinded, amended after the incapable person becomes capable? And yes, if a person's capable, they can revoke a power of attorney document, they can amend it, they can get rid of it entirely, they can do whatever they want as long as they're capable of doing that. And then how does one of property back out? You have to resign. If you haven't acted, it's a very simple procedure. You just say you don't want to act. If you have acted, there are steps that you have to take to resign, and you will likely want to put together your accounts just to show that everything has been managed properly. And if you're taking compensation, then you'll want to get sign off from that by the new attorney for property, or perhaps even pass your accounts in court at that stage if you're worried. So I'm just going to go through more of the questions. I'm moving on now to the duties of an attorney for personal care. So I am going to try to address some of the questions now for powers of attorney for property. So I have a question that if the POA is done by somebody other than a lawyer, what fees can be charged? I'm assuming that they're talking about charges to create the document. I'm not sure any fees should be charged by somebody other than a lawyer. They do have copies of these documents on the internet, on the Ministry of the Attorney General website, and that type of thing. And if you're printing those off there and filling them in, nobody should be getting any money. I recommend that people get these documents created by lawyers. Lawyers often have set fees for that. They are important documents, and the lawyer can take you through the pitfalls and the things to consider. Not everybody has the money for that, and that's why these documents are on the internet as well. But I would not give anybody else money to create one for you other than a lawyer. Can a POA force a family member to move from a property in order to sell it if the POA and will are silent on the matter? So I assume here that the family member is not the incapable person. So if it is the incapable person, the attorney for personal care will get to this. But if it's no longer safe for the person to live in the house, if they can't afford to live there by themselves, then yes, you can force them essentially to move, taking into account their wishes, and we'll talk about that. Otherwise, if somebody else is living in the house and the money is needed to care for the person, that person should be paying rent, they should be paying the taxes, et cetera. That should not really be covered by the incapable person. And yes, if the property needs to be sold, then that person should be forced to move from the house. And there are steps that can be taken if the person isn't willing to go voluntarily. Again, there are other circumstances that could arise if the person who's living in the house is a family member who is incapable themselves. Maybe it's a child with disabilities, and there are different issues that would need to be taken into account in those circumstances. So again, I would talk to a lawyer as the facts of the specific situation may change the advice in that. Can a power of attorney for property outsource their job to a third party to help spread the load? Not really. You can't delegate your authority. You can get somebody else to manage the assets, to manage the finances, the investment account, but basically you're the one responsible for any decisions made. So there. There's a question about signing separation agreements by an attorney for property. Basically, yes, you can have an attorney for property sign a separation agreement for the spouse, but there are questions about the capacity to separate and that type of thing. So, if the capable spouse has instigated separation proceedings, then yes, the attorney for property for the incapable spouse can absolutely negotiate the separation agreement and sign that agreement on their behalf. There is a different question about whether or not the attorney for property can instigate separation proceedings on behalf of the incapable person, but that's not really the question, but that may change the answer depending on the actual circumstances of that question. And what about compensation when acting as an attorney, but the donor, so the person who granted the attorney for property is still capable but not really able to do things? Yes, you can still take compensation in those circumstances, but you should get the capable person to sign off on it. So, you need to make sure that they know what you're doing and that they're okay with you taking the compensation because it's their money. And you would likely want to get that in writing. And again, talk to a lawyer about that. Okay, and does property include household items, personal items, artwork? Yes, that is property. Anything that you would consider your own property is included in the power of attorney for property. So as I said at the outset, that person can do anything with the person's property that you could do yourself, except make a will or other potentially testamentary dispositions and designations. So what if family members attend the home of the incapable person when the attorney is not present and items walk out of the home with them? So that's a difficult question. That gets to the abuse, right? So no, they shouldn't be doing that. They should be going through the attorney for property for all of that type of thing, because those things have value and they may be set out in the will. And the attorney for property is responsible for that. So you should try to get those items back if that happens. Now, obviously, sometimes that can be very difficult. And the question is whether or not you want to pursue legal action to get that stuff back. And that's a question you would have to think about in terms of the value of those particular items, weighed against the cost of litigation to have them returned. But you should certainly make a list of those items and make sure you know who got those items, so that can be taken into account after the incapable person dies. And so which power of attorney would allow the attorney to step in as a director and officer of a corporation? That's the power of attorney for property. There are steps that would need to be taken with respect to corporate resolutions and other issues in order to affect that change, and that can be complicated. So is it standard procedure to ensure that all powers of attorney vote the same way or have a majority to consent with respect to how to spend the money? So there is no standard procedure. So if you are appointed jointly, then you both have to make the decision. And that's why sometimes it's good to have 3 people or one person, an odd number of people appointed. If it's one person, obviously that person gets to make the decision. If it's 3, you may want to have a majority rules clause in the document so that 2 out of 3 people have to make the decision. And they can overrule the third person. So I think that's most of the questions answered. So we can move on to the duties of an attorney for personal care. And so what are the duties? You must perform your duties diligently and in good faith. You have to explain to the incapable person what your powers and duties are, and to the extent possible, include them in the decision-making process. If there's a wish related to personal care, and this is where this can get complicated, it should be followed. If the wish is impossible to follow, you don't have to honor that wish, but you must act in the incapable person's best interests. And obviously that's subjective, what the incapable person's best interests are, and that's where a lot of fights amongst family members arise. You have to consult with supportive family members and friends before making decisions. You must allow visitation with supportive family members and friends. You can't cut people off. Even if you don't like them, if they've been a good friend to your parent or whoever you're acting for, then you have to allow them to visit. You know, as long as they're not upsetting the person or abusing the person, and obviously that's a different circumstance. You should keep a record of the decisions you make on behalf of the incapable person. You have to foster the incapable person's independence to the extent you can, and you have to consult with the attorney for property. And again, that's because you may want to get the most expensive care possible for the person, but it may not be possible because the person can't afford it. And so those are conversations that you have to have with the attorney for property. So as I said, Section 66(3) of the Substitute Decisions Act says that you have to take the wishes of the incapable person into account when you're making personal care decisions for them. And this includes all personal care decisions, not just treatment decisions. And I'll get to treatment decisions later because there's a different act that can apply. So Section 66(3) explicitly says that if the guardian knows of a wish or instruction applicable to the circumstances that the incapable person expressed while capable, the guardian or attorney shall make the decisions in accordance with the wish or instructions. And so the attorney shall use reasonable diligence in determining whether there are such wishes or instructions. And sometimes these wishes will be set out in the power of attorney document directly, or they may have been told to the attorney when the person was capable, or they may be written down somewhere else. And so a later wish or instruction expressed while capable prevails over an earlier wish. So, if originally, when the person was younger, they said that they wanted any measure taken to extend their life, but then when they, maybe in 15 years from then, they change their mind, the later wish takes priority. And so if there's no wish or instruction, or if it's impossible to make the decision in accordance with the wish or instruction, the guardian shall make the decision in the incapable person's best interests. And so, an example that we often see is a person has expressed a wish to stay in their own home until they die. Sometimes this just isn't possible, however, and so the attorney can't follow that wish because there's not enough money to get the care. It's not safe, if the person is wandering and or has other behavioral issues, and it's, or they fall down the stairs, or there are all sorts of things that could make it impossible for the person to stay in their own home. Then you can make the decision to move them into a long-term care facility, for example. But you have to make that decision in the best interests of the incapable person. So how do you determine the best interests? So you have to take into consideration the values and beliefs held by the individual, as well as their current wishes, if you can determine them. So you can talk to the person about it and ask them what they want now. And so you have to consider whether the decision is likely to improve the quality of the person's life, prevent the quality of the person's life from deteriorating, or reduce the extent to which, or the rate at which, the quality of the person's life is likely to deteriorate. And clearly this is subjective, and these are really hard decisions. And you want to consult with family members and friends of the person while making these decisions. So I want to talk a little bit about the best interests of the incapable person set out in the Healthcare Consent Act. So this is the other act I was talking about earlier, and this relates to treatment decisions. So the Healthcare Consent Act provides a hierarchy of people who can make treatment decisions for an incapable person. If there's an attorney for personal care, that person makes these decisions. If there isn't, then it's first the spouse, then the children, then brothers and sisters, and there's a list of people who can make the decisions on their behalf. So the Healthcare Consent Act is concerned with the capacity to make decisions in relation to specific treatment, admission to a care facility, or personal assistance services. An attorney for property could also be asked to make these treatment decisions under the Healthcare Consent Act. So first of all, you need to look at the power of attorney document to see whether there's a provision that applies to the circumstances. If there's not, then you have to make the decision in the best interest of the person. And of course, this is a subjective test, and these are circumstances where the decision maker, you and a doctor, for example, may disagree as to what's in the person's best interest. And so I'm going to go through a couple of cases here about treatment decisions and other personal care decisions because I think they're instructive and they give people a good sense of the types of decisions people have to make and the types of issues that can arise. So there's first case is a case called Jansen and Jansen. And in this case, a man was in a vegetative state. His wife made personal care decisions on his behalf. And the physicians told her that he would not get better. So she made the decision to withdraw life-prolonging treatment to allow nature to take its course. The man's sister applied to become his guardian so that she could maintain aggressive treatment, hoping that he would recover. His wife then counter-applied for guardianship, saying that her husband had expressed his wish to her that he die naturally. And in this case, the court sided with the wife and said that her care plan for the man better represented his wishes. In another case, Scardoni versus Harlach, a woman suffering from Alzheimer's and pneumonia. She'd been placed in intensive care twice. And her daughters, who were her attorneys for personal care, were advised by her doctors that certain treatments that had been provided in the past should be withheld in the future. The daughters refused to consent, and the physicians applied to the Consent and Capacity Board, and the board overruled the daughters and sided with the doctors. The daughters then appealed the matter to the court, and the court allowed the appeal, finding that the express wishes, the woman had expressed wishes that were nonspecific about sort of what type of treatment she would want in these circumstances, needed to be considered when determining a patient's best interest. And so the care was to be provided in the future. And then in a different case, Barbalov and Cerrone. And so in this case, the father was in a vegetative state with no chance for recovery, and the doctors proposed a treatment plan to the family, including the son, who was the attorney for personal care, such that if the father got worse, he would be taken off a ventilator and not put back on. If his breathing worsened, and no CPR or dialysis would be given, so ultimately he would pass away. The son argued that this did not reflect his father's wishes, even though the power of attorney document explicitly provided instructions not to prolong his death with life support. The son argued that the father's English was poor and said that he would not have been able to read the document. So the doctor applied to the Consent and Capacity Board, which is set out in this process to apply to the Consent and Capacity Board is set out in the Healthcare Consent Act, and found that the son had not complied with the principles of the board found that the son had not complied with the principles of substitute decision making when the son was ordered to comply with the power of attorney for personal care, and that meant withdrawing treatment. The son appealed, and the court held that the board had erred in concluding that the power of attorney document consisted of a prior capable wish. But that said, they still upheld the board's conclusion that the son had failed to give or refused consent to treatment in accordance with the principles in the Healthcare Consent Act. So they agreed that treatment should be withdrawn in this case. There's a case called Conway and Jacks. This one's very different. The Conway had been found not criminally responsible for a crime, and then he'd been detained in psychiatric institutions where he'd refused to take antipsychotic medication. So eventually he was found to be incapable of making treatment decisions for himself, and his mom was appointed as a substitute decision maker. And she refused to consent to the taking of antipsychotic medication on the basis that her son had previously refused. And the court held that he should be forced to take the antipsychotic medication. And I think importantly for these types of decisions, found that prior wishes are not absolute and should be applied in the context of the relevant circumstances. So this gives family members some flexibility in terms of how they interpret or apply prior capable wishes. So if you're concerned about the meaning of specific provisions in power of attorney documents, and you're concerned about making these types of decisions for an incapable person, again, I would talk to a lawyer. But I think most importantly, you should consult with other friends and family members. I think that's where a lot of issues arise, is if the attorney is not consulting. Because people, if they don't understand the decision, they're less likely to agree with it. So how do you protect yourself from liability as an attorney for personal care? And it's a lot about what we've been talking about here. So if you're acting in accordance with the duties that we've talked about, and you're acting in good faith, then you're immune from proceedings for damages in the fulfillment of your responsibilities. You can also ask the court for directions under Section 68 of the SDA before making these decisions. So, if there is a treatment decision to be made, or you're really worried about your siblings, then you can apply to the court and have the court authorize you to make that decision. And that gives the other side an opportunity to make their arguments to the court, and you're protected by that decision. And so, again, that can be an expensive process, but in certain cases, and if the assets allow it, then I think that's the safest way to proceed if you're really worried about family members. And then again, talking about the duty to consult. So there are some cases about the duty to consult, which I think again are informative. So there's one called Palin and Elbrecht. Here, the son and daughter were confirmed the guardians for their mother after their brother attempted to remove them. So that the third child. The brother alleged a breach of the Substitute Decisions Act on the basis that they had chosen a nursing home without consulting him and didn't employ a German-speaking companion for their mom. The court found that in this particular case, consultation would have been useless and futile, and therefore the son and daughter were not required to consult with the brother about the move. So if you have a family member who is particularly aggressive or hostile, and you know that they will disagree with you, you should still try to consult with them, but there is case law to support you making that decision without them. Again, that doesn't stop you getting into a court proceeding, but it should give you some protection, at least at the end of the day, that you can make the decisions that are in your parents' best interests. So in another case, Oberg versus Presta, this was a case involving two siblings again, one of whom was appointed the guardian of their father. The relationship between the siblings deteriorated, and the brother had the sister removed. The court found that the daughter had done an excellent job in attending to her dad's personal care needs. She'd found a great place for him to live. She'd made sure he had wine with meals and arranged daytime exercise, but she failed to completely to consult with her family over moving him into a nursing home. And in fact failed to tell him that he had been moved, so they didn't know where he was living. And because of this, the court removed her as the guardian. And so lastly, there's a Roland versus Roland case. And this one's interesting and sort of is instructive about aggressive positions taken in court and to going to court too quickly, I think. And here, son and mother brought competing applications over guardianship of their incapable sister and daughter. The daughter had historically lived with the mom. When the son discovered his mother's estate planning arrangements, so I didn't leave him enough. He took his sister from his mother's care and moved her to North Bay without her permission. And so the brother's failure to consult and his highly adversarial conduct were taken into account when refusing his application for guardianship. The daughter was returned to the mom and her other sister's care, and the mom and her sister were ultimately appointed joint guardians. And this is likely for continuity. After the mom is no longer able to look after the sister, then there's somebody to step into her place. So I'm just going to look at a few more questions that I think have come in. We've got a few more minutes, and I'll try to answer as many of them as I can. So does the POA have to keep records and show those records of payment and compensation to the alternate? You should certainly keep records and have them available. The only person that you are really responsible to during the incapable person's lifetime is the incapable person. But to the extent that the beneficiaries question what you've done with the person's money after that person dies, or if they're worried about you acting not in the person's best interest during their lifetime, then they can challenge you at the time. So they could certainly apply to the court to look at those records. I don't know that you necessarily have to show them to the alternate, but I'd need to know a little bit more about the circumstances. So please explain the jargon passing of accounts. So again, this is a court application, and what it means is that you put how you've managed the person's money into court format, and that's set out in the rules of civil procedure, what that court format is, and it's basically a listing of every single transaction that you've undertaken. So you start with the opening balance of the person's assets, and you show all the investments, and then all of the capital receipts, so any investment money that's come in. If you sold a house, you show the money coming in, and any money that's gone out. So every payment that's been made on the incapable person's behalf has to be listed and the reason for that payment. And then you show a balance at the end of the period. So if you're passing your accounts from sort of January 1st to December 31st, you show the opening balance and the ending balance and everything that's happened in between with every single asset. And then you go to court and you ask the court to approve what you've done. If you've taken compensation, you ask the court to approve your compensation. Now, there is a procedure set out, again, in the rules of civil procedure as to how this court process is undertaken. So you serve everybody with your materials, including, if they want all the voucher materials. And what that means is the backup materials, so the receipts and the bank statements and the invoices and any other document you have that supports the transactions that you've undertaken. And they have the opportunity to object to, generally people are objecting to compensation, but they may object to an investment. They may say that you didn't invest properly and that there's not a high enough return, or that you invested in a way that was too risky. So there are all sorts of reasons a person can object, too many to list here. And then you explain what you've done, and a court decides who's right, basically. Often nobody objects, and you get the court judgment sort of over the counter in the court, and the court just grants the judgment saying that what you've done is okay. Usually, if you're acting as an attorney for property and you are passing your accounts, it's because you're worried about how the other beneficiaries are going to act, and so there will likely be objections. And I hope that explains that. And so if you act as an attorney for property, is it important and necessary to read the will of the incapable person? Absolutely. Yes, you must read the will. So if there's a house if there's a house or a cottage property, for example, that's gifted to somebody in the will, you cannot sell that property unless the person needs the money from the sale of the property. So yes, you must absolutely look at it and preserve the property that's gifted in the will. So if somebody is incapable but is still trying to give instructions, I assume we cannot fulfill it if the power of attorney doesn't agree. If I understand the question, I think what you're asking is that the power of attorney doesn't agree with something that the incapable person wants to do, then, and if the person's incapable, then yes, it's up to the attorney for property to make that decision, taking into account the incapable person's wishes and thoughts. But if it's not possible to follow those wishes and thoughts, then yes, the attorney for property makes the decision. Is that it? And so I think that's it for today. I'm hopeful I got to most of your questions. And obviously, if you have any follow-up questions, feel free to contact me. And thank you for